Hello and welcome to the CPR Institute's YouTube channel and our blog and our website. I'm Russ Bleemer. I edit and write alternatives for the CPR Institute. We have posted today a story. This is on Monday on the Monster Energy case at the U.S. Supreme Court. The court declined cert on it. Monday is a very significant day for the court. There were cases on abortion rights and the constitutionality of the Consumer Financial Protection Bureau, as well as an important case on the federal death penalty. But still, in our area, in our narrow arbitration world, Monster Energy was an important case. Many arbitration fans and foes had hoped the court would take the case and deal with the important issue of arbitrator disclosure in it. The case would have dealt, if they had taken it, with vacating arbitration awards under the Federal Arbitration Act. I'm joined once again by Phil Lurie in New York, Richard Faulkner in Dallas. Monster Energy would have updated the 1968 case of Commonwealth Coding. The specific thing it would have discussed was evident partiality, and using evident partiality to vacate an arbitration award. That comes from the Federal Arbitration Act, which dates back to 1925. You're dealing with case law of more than 50 years old, statutory law of more than 100 years old, so almost 100 years old. So many thought it was time. Many thought it was past time to deal with these issues. Rick, arbitrations and disclosures are going to go on regardless of the fact the court didn't act. What happens next when you're taking a case on as an arbitrator and as a provider?
I think the case law is already fairly clear. Disclose, disclose, disclose again. You can't get in trouble for too much disclosure, but you can surely get in a great deal of difficulty, and an award may be vacated if you make insufficient disclosures. One of the things you hit on was that the Federal Arbitration Act is effectively a product of the Calvin Coolidge administration and has every consumer and employee protection that Silent Cal would have included in a law, which is to say there aren't any. And consequently, the fact that the U.S. Supreme Court has not revisited this issue since the 1960s suggests that it's about time that they revisit it. One thing I note is that many of the judges who face these issues on motions to vacate are not themselves very familiar with arbitration. Once you get outside of the major urban centers such as New York, Chicago, Houston, San Francisco, LA, it becomes increasingly difficult to find judges who do understand the importance of arbitrator disclosures. I practice in the Eastern District of Texas, and so I'm spoiled because the chief judge is Judge Gilstrap is a fully qualified international arbitrator. Judge Troncali is a fully qualified international arbitrator, and Judge Mazant wrote the Ezekiel Edwards case analyzing the ethical dilemmas and problems posed by the National Football Players League and NFL arbitration provisions, which effectively allow the commissioner to dictate the arbitral outcome. And Judge Mazant had quite a lot to say about that. People forget the Fifth Circuit did not reverse him. They found they had no jurisdiction, which is a totally different kettle of fish. And when you present these matters to state court judges, very few of them actually have much experience with arbitration. And it's important to recognize if you're west of the Mississippi River, many of the judges are elected, and nobody gets elected as a judge by proclaiming their expertise in arbitration. I've been a trial judge. That was never an issue on anything I ever saw or asked. I'm married to one, same thing. She's never been asked about arbitration in any political forum. And it's important to recognize that lawyers need to make these cases and set up everything for the judiciary to understand what's going on. And I think Phil circulated to us that wonderful Pennsylvania case, and I'm going to ask him to talk more about that because it is now one of the first cases interpreting Monster Energy.
Yeah, and Rick, I appreciate that. Phil, before you do that, I know you've got a lot to say about the Pennsylvania case and Monster Energy being declined, but I didn't want to lose a point that Rick made up top. he had said that it would be good to revisit after 50 years Commonwealth coding. No legislators are elected because they're arbitration experts and wonks. But if you were a legislator and you were going to amend the FAA, and we've talked about this before, would you go after this evident partiality area? Does that need updating, or is that good as it is? Rick did say the judicial part is
I think it needs updating. It seriously needs updating. And one of the reasons for that is that the Commonwealth Codings decision was issued in a day and time when there were not really professional arbitrators out of the except in the collective bargaining arena. And there you had two sophisticated parties on either side picking arbitrators for their knowledge and expertise. You did not have major $100 million a year profit-making institutions that were in the business of arbitration. We hadn't yet seen the fiasco of National Arbitration Fora, which everyone now concedes was a rigged game, rigged against consumers. And you know, the studies in this area indicate there is a huge problem with the repeat player effect. The AAA was absolutely excoriated in a series of articles many years ago by the major San Francisco, I think it's the Examiner or the Chronicle, series of articles outlining how it was asking its arbitrators to go and actually recruit businesses to put AAA arbitration clauses inside of their agreements so that it would generate more business for the AAA and for the arbitrators. JAMS got the brunt of the criticism in Monster Energy, but now those of us who work in this field see that JAMS has the platinum standard of disclosures. I mean, my God, they give us things I've asked for from other institutions like the AAA for years and get told, no, we don't give that out. It would violate confidentiality. But now the Ninth Circuit says, no, not so fast. It's essential. And you know, the Pennsylvania case Phil's about to talk to effectively said the same thing.
Yeah, I want to give Phil a shot at that. Would you update Commonwealth Codings first, or amend the FAA first, or both?
A very good question, Russ. I fully agree with what Rick has been saying, and it is unquestionable that evident partiality is an area in which could benefit from some very well-reasoned legislative reform. There's a big problem with reforming the FAA, as Rick fully knows, is that they're just, you have a big business lobby and you have an equally big consumer lobby and so on and so forth, and employee, employer, all of that. So you really, it's very difficult to come up with any kind of consensus in terms of how should the FAA be modified. In 1925, when it was passed, we were at a time when arbitration was basically about two things. One was industry-specific arbitrations, and the diamond industry, the reinsurance industry, and so forth, and labor arbitration. And technically, the FAA has passed, it wasn't even supposed to apply to labor arbitration. It really doesn't technically still, although it's relied on, it's relied on as—
I was going to say the effect of the FAA is it kind of oversees all of this stuff.
Yeah, the Section 301 law and the FAA law, judicially created bodies of that are sort of interchangeably used nowadays. But and even then, I think the Railway Labor Act had been passed by that time, or maybe it hadn't. But as you can see from Section 1's exemption, there was a lot that they were in the labor side that they were trying to keep out. But so I would try to legislate. Now that the problem is, even if you have a consensus, it's what exactly do you legislate? And
yeah, here we go again.
Remember, all the FAA has to say about evident partiality is that the award may be vacated for evident partiality or corruption in the arbitrators, Section 10A2. So, we got from there to this whole business of disclosures and everything else via Commonwealth Codings and the cases that preceded it and came after it. and it's been a whole big, largely, I think, misunderstood area of law. And in one way that it's misunderstood, I've argued a number of cases in the circuit courts of appeal on evident partialities. You were there for
As
my
have I.
Second Circuit, and yeah, Rick has too. We both have, and you know, when you talk about argue and brief, it's quite a list. But what I find is that there's a lot of confusion about it, and you know, if you disclose an interest, a material interest that that if it were undisclosed would create a basis for vacating an award, you know, if you're the side that's potentially challenging it, if you object to the disclosure, you can still get the award vacated. You know, in other words, the disclosure doesn't make a material, you know, a material conflict just go away. I mean, if I go, let's say I'm appointed as an arbitrator, and you know, and one of the parties is my daughter, and somebody else on the other side, and I say, oh, by the way, everybody, you know, my daughter Michelle is one of the parties in this case. Well, you know, if they object to that, the fact that I disclosed it is not going to do a whole heck of a lot of good. Now, you know, what you have now is the good arbitrators, and there are many, will try to over disclose, and that's everybody agrees. I don't think I've ever met anybody who disagreed that over disclosure is a very good thing. One bad thing that has happened, though, because of it, is that there's become a whole cottage industry of how to deal with arbitrator disclosures, and it gets to the point in some of these arbitrations, you know, particularly I've seen it on the industry side, but it's probably, I think you also see it in AAA arbitrations and the like. It is that you have people very aggressively, you know, asking questions about background and on and on and on. And it can get you know, pretty uncomfortable. But it is what it is. And if you've got to, you know, if you have the disclosures, you're much better off than not having them.
That is certainly what happened here. JAMS thought it was being reasonable. I was just looking for the exact word that the court came up with, but they thought it was being reasonable and brought it to this level. And then the court looked at it and said it just wasn't enough. I thought it was very interesting, though, that the Ninth Circuit did, and this could have possibly factored in with the play of evident partiality with the Supreme Court. The court seemed to think that this was something that JAMS could easily do, sort of suggesting this was merely a clerical error, and said that under the laws of California, the strict arbitrator disclosure laws, that they're required to do this anyway, and they should just get it better the next time. So,
and there's a question whether those California laws really apply, and you know, you're basically talking about a whole different standard for evident partiality under California state law than you would have under the FAA. So unless you have something like a choice of law clause that clearly and unambiguously states that California arbitration law is supposed to apply, then, you know, under Volt and Master Bono, you're going to, you know, FAA is going to apply.
I was going to say, Rick, I think Rick's reference to the JAMS being under the gold standard was to that they're operating under that higher. It's an Irvine, California-based company. Rick, correct me if I'm wrong. Your reference to the gold standard was they're already operating under the terms of the California state law for everything.
Yeah, JAMS is, and in fact, I equipped the platinum standard because they're now going over, you know, and above anything that is required. And I would kind of disagree with Phil in the sense of the Federal Arbitration Act preempts state law inconsistent with arbitration. And how are higher standards of ethics, greater disclosure, and more emphasis on the freedom of the parties to make reasonable, intelligent, informed choices inconsistent with the Federal Arbitration Act? I don't think they are. And I think that one of the issues is that the folks who don't particularly like decisions like Monster Energy are not very happy with the fact that it becomes much more difficult to game the system for arbitrators to, be creative in their disclosures, as was the case in the Tenaska versus Ponderosa Energy case cited in the Ninth Circuit Monster Energy decision, which is a Texas Supreme Court decision where the allegations were, and I think the evidence ultimately showed, the arbitrators' disclosures were somewhat creative, and they did not give the opponent of that particular party-appointed arbitrator full, fair, and clear understanding of what the potential conflicts were. And that is a huge problem. Phil and I have been doing international arbitration for decades, and I think we've all seen some very creative disclosures that, but for the fact that we happen to be ourselves repeat players in the arena, we would not have necessarily spotted exactly how creative some of these disclosures are. And I've taken up the same issue in the U.S. Fifth Circuit in a case called Dealer Computer Services versus Old Colony Motors, where the arbitrator played games with everyone and just didn't answer one of the questions, and then come to find out she had at least 5 cases where she stood to make a minimum of $50,000 in arbitral fees, sometimes double that in each case, and yet obscured that from Old Colony Motors. Fortunately,
I'm sorry.
We were able to bring that to the Fifth Circuit. Unfortunately, they did not uphold the vacatur that we obtained in the district court, and again, the U.S. Supreme Court denied cert.
I just wanted to clarify that in the link below to our blog post by Heather Cameron, you'll find a link to Monster Energy in the full case, which in turn has the sites and a link to Tenaska as well. Rick, I'm sorry, Phil, you wanted to respond to those levels of disclosure?
Oh, yeah.
And I wanted, if you could, bring in the Pennsylvania case, because we didn't include that in the blog post today. We stuck to Monster Energy, but we just saw last week it followed Monster Energy.
Well, yeah, and this is a great example of how complicated arbitration law really is, and one of the most challenging aspects of arbitration law, it involves the conflict of laws both vertically, state and federal, and horizontally, federal to state or state to state. So, what Rick was saying, well, it doesn't hurt. It shouldn't be. Under the FAA, if a state whose law would otherwise apply in a diversity case, if that law provides for stricter standards of evident partiality, in the sense that it's easier for the challenging party to vacate an award, there's a very good argument that would be preempted, because it makes awards less enforceable. I mean, and I fully agree with Rick when it comes to, we got to keep people from playing games and everything else. The other point is that with JAMS, I think, Rick, what you're saying is that it's the JAMS guidelines and the JAMS rules that impose these standards, just like we have those wonderful AAA rules that purport to do the same thing. The problem with that is that in the Second Circuit, and probably many other, I think it's a lot of other courts, I know it's in the Second Circuit, but those are not binding on the court, and the only time
Correct.
they could be binding on the court would be if they're clearly part of the party's agreement. And then I say, well, if it's part of the party's agreement, what about Hall Street versus Mattel? Can we go under 10A4? This is a great example of, and Rick and I are always trying to explain to people why arbitration is so complicated. This is a great example of, and this is one tiny piece of this whole Monster Energy case. Let me see if I can tie in this Pennsylvania case. I think there's a lot of reasons, and I don't know if we have time to get into all of them, but as to why the Supreme Court didn't grant cert in this case. But one reason is that the petition for cert was brought on the assumption or the assertion that we have conflicting standards among the circuits about evident partiality. And that is, to some extent, is true. there are differently, the standards are articulated differently. The point is, though, is that the standards are mostly expressions of mood, I think. Like for example,
Yeah, the real conflict needed to be developed more. It wasn't so much as conflict as a bunch of parallel interpretations of evident partiality. They're not incompatible, they're just a little different.
Yeah, they're a little different, and
Yep.
what proves that, which is, and I think Rick, you sent me the case, or Russ, you sent me the case. Rick thought I said I learned it from you guys, but the NTT, so it was probably Rick, but the NTT data case applied the Second Circuit standard, which is a reasonable person would have to conclude that an arbitrator was partial to one of the parties.
Yeah, let me just jump in. The case that we're referring to, this Pennsylvania case that followed Monster Energy, was decided on June 23rd in Pennsylvania's Eastern District, the U.S. District Court for the Eastern District of Pennsylvania, civil action number 20-CV-0686. It is Sarah Martin versus NTT Data, Inc. Sorry about that, Phil. I just wanted to get the name of that case out there so people can find it.
No, that's very helpful.
I appreciate that. I think I lost you. I can't hear you. I'm sorry.
I can hear Phil, but I can't hear Russ.
You dropped out, Russ, I think.
Yeah. Well, Phil, do you want us to keep talking about the Pennsylvania case, or?
Yeah, I could go on. Russ, we can't really hear you right now, but I'll kind of try to finish.
I just had. Did you get some interference coming in there?
Yeah,
yes,
you
we
were
couldn't
blocked
hear
out
you at
for a
all.
while.
Yeah, I saw when I went to get NTT Data, a website launched with a report on the Supreme Court this morning. So I apologize for that if that came in, but I'm back.
No problem.
Yeah. But anyway, the NTT data case had very, very similar facts to Monster Energy, and you had basically two things, the same two key facts as you had in Monster Energy. Fact number one, you had an arbitrator that had a financial interest in jams. Some of the jams arbitrators have financial interest. This one did, just like the arbitrator in the Monster Energy case did. The other fact was that you had a party who at least arguably had done substantial business with jams and based on the number of repeat cases that had, again, this is a situation you see again and again and again, because if you have a form contract and you make jams or the AAA or CPR or whoever, or the arbitration provider, then by definition, in most cases, you're going to end up being a repeat player. So anyway, you had those facts. The court applied the Second Circuit standard, which has been adopted by the Third Circuit in, I think it's the Freeman case. And it said, I'm looking at this and it sure as heck looks like there's a ground for vacatur based on evident partiality. But then the court turned around and said, but there's one problem. The other party kind of took a wait and see attitude about these subsequent disclosures that had come in about the interests and all. And as a result of that, there's a waiver. So the point of all that is that it doesn't really make a difference whether the standard is a reasonable impression of partiality or a reasonable person would have to conclude standard of the Second Circuit and other circuits.
And the result in Pennsylvania was that the arbitration award stood, which was not the case in Monster Energy, which was why Monster Energy seemed like a good case to take to the Supreme Court. Anytime you have an arbitration award overturned, the reviewing court is gonna have a heightened sense of review on it. This NTT data case is probably not something we're going to see a lot more of. It may certainly go up to the Third Circuit where it's located, but I don't know how much further it goes after that. We have dived deep in. Rick, Rick Phil, do you have last words? Do you want to sum up?
Sure.
Arbitration will obviously go on, and evident partiality challenges we'll probably see you guys arguing them at some point down the road, as we have in the past, right?
But
I
you
think
showed up
that's
for my
virtually
last ones.
guaranteed.
We did. We saw the last one.
but
Rick,
the-
All the
CPR,
interns with you too.
Rick, CPR sent a delegation to Phil's Second Circuit argument a couple of years ago, and the Second Circuit was not nice to Phil, but he took it in stride because he won the case, so it was fine. And that's one of the things.
In that case, but we pulled it through.
These cases appear when you see what the Pennsylvania court said about jams in the arbitrator. When you look at Monster Energy, some of the language in there, it's really, really tough. But when the court goes back and applies Commonwealth codings and it looks to the statute and all, the arbitration awards are going to tend to hold up.
Oh, yeah, they will tend to hold up. But here's the other thing. Too many lawyers have not laid an evidentiary predicate for showing the conflicts, for making the requests for disclosures, for effectively papering the issue so that when it's brought to a trial judge, the judge can then look at it and say, wait a second. Is this really acceptable? Should that arbitrator have made more disclosures? Should an administering organization that it has its own self-interest and also has information about what the arbitrators have sat on, shared that with all of the parties? And that's particularly true in the areas of consumer and employment, where one side's attorney, the repeat player party, and the administering organization both have full knowledge of the arbitrator's potential conflicts, and the only odd one out with little or no knowledge are the attorneys for the consumers or the attorneys for the small businesses, which is what I tend to represent. And they're sitting there going, wait a second, everybody in this, the administrator, opposing counsel, opposing party, all know this arbitrator's potential conflicts, and we're the only ones being kept in the dark. So you have to make the challenges, you have to ask for the information. And if you don't do that, exactly as happened in the Pennsylvania case, the judge found that that party had waived it. Mm-hmm. And absent the waiver, it may well have turned out differently.
Yeah, and again, to be clear, another reason Monster Energy was shocking was because it was a business-to-business case, and some of the language in there, particularly in the dissent about the utility of arbitration, was really fiery and surprising. These came from the court papers. I don't remember exactly whose, but Monster Energy was about $5 billion, a $5 billion company, and City Beverages, a distributor, was a Coca-Cola affiliate, which is about a $3 billion company. In Pennsylvania, you were dealing with an individual plaintiff, so it was a much, much different setting. But that's another reason why Monster Energy is getting the kind of treatment we're giving it here, because it was very much so a business-to-business commercial arbitration. Bill, do you have a last word?
Yeah, I have lots of them. I'll try to keep them as few as possible. but and this is something I think, and Rick and I have talked about this too, and I think we both agree that this case has opened up a huge Pandora's box or can of worms or whatever you want to call it about arbitration providers in general, and some of the you know, what are arguably systemic problems that you have in the whole concept of an arbitration provider in some circumstances when it comes to repeat players. And again, when you can have parties that are disadvantaged and whatnot. And in Monster Energy, the court, I have to give the Ninth Circuit credit for doing their best to try to deal with it in a way that made sense. And probably it's a good compromise, because yes, Jams is going to have to make more disclosures, and maybe Jams, who knows, maybe they're going to have to change some of the, some of their financial structures, or that's.
Well, they had said at the time that they were immediately revisiting their disclosure processes and all, and presumably have long readjusted that.
They have. I've got
California
some of their new disclosures.
And look, Jams is a great organization. I've always loved Jams. I've used Jams. I've met high people from Jams through Rick, actually. But they're very good and they're very professional. Just the CPR is wonderful and professional and everything else.
Which also said it is looking at its requirements in light of Monster Energy back last fall as well.
Absolutely, and that's the right thing to do.
It's just natural. I'm sure the AAA has as well.
Being good.
Well, I would throw out
the AAA will
something.
have to too. I know Rick has said he's had problems in some of these AAA cases with getting some of these disclosures. Now, maybe now the AAA will be more amenable to that. I don't know, but
Well, I think one of the
there's a
things,
lot of this really does expose a kind of a problem that you could say at least it's arguably systemic in the arbitration provider industry.
y'all, it may actually
and I'm
be worse
confident
than
that
that.
it will be solved in a way that makes sense.
And the reason I say it may be worse than that is we're
Yeah.
seeing a continued expansion of specialty trade type arbitration organizations that are now reaching out to purportedly bring in arbitrations involving outsiders. Phil and I both have a lot of experience in the insurance, reinsurance arbitration world, and you have organizations there that we're both familiar with that previously Arias simply did arbitrations between insurance companies and reinsurance companies, and he tended to represent insurance companies. I represented a number of alien reinsurers. Our clients were sophisticated. Nobody was taking advantage of anybody in this deal, very much like Monster Energy. Yet now that organization is reaching out to do coverage arbitrations, which puts them in a position to provide industry-tied arbitrators who have to be either officers, directors, or retired officers or directors of an insurance company or a reinsurance company before they can sit as arbitrators. If you represent a small and medium-sized business in a coverage dispute, that does not sound like a qualification of the arbitrators that I want. I'd rather a non-administered arbitration, some way to get away from that kind of closed universe of arbitrators. And, and I don't mean to pick on Arias, but there are similar things in the construction field. There are similar problems in a number of other industry-related areas. It's come up in grain. And so that tends to be more of a problem that may be focused a lot more as non-party, non-industry insiders are subjected to arbitration involving insiders, because there you have, again, the repeat player effect becoming a huge problem. And Phil made allusions to amending the FAA, and actually some of my clients managed to do that. Quite a number of years ago, I represented hundreds of automobile dealers, and the National Automobile Dealers Association sponsored amendments to the FAA. We actually had one senator stand in our way, Jeff Sessions, later the Attorney General, and now running for the U.S. Senate again. And the way we got around Senator Sessions was we went back and we created an amendment to the Department of Justice Appropriations Act and got it passed that way. And so now automobile dealers are the only businesses in America that an agreement to arbitrate is only effective if entered into after the dispute has arisen. The exact thing that consumers, employees, and small businesses have been asking for ages and been unable to get. There is a similar provision relating to what do they call them? Payday loans for members of the military and their families. And it's very obscure. It's clearly modeled on what was done in the Motor Vehicle Automobile Dealer Association area. And after we managed to go with NADA and get that change to the FAA through the back door, then after we succeeded in doing that, what do you know? Chrysler went back and reinserted the AAA, the very organization we were trying to get rid of, back into its franchise agreements. And now you're faced with the same situation. And if you read the way that the language is drafted in that particular franchise agreement, it is horribly disadvantaged to Chrysler dealers. And yet they're sent right back to the same organization that we made a great effort to get federal legislation passed to extricate our clients from.
Rick,
So it
that
all
is,
comes around, and we're going to be back again.
that's great background. I appreciate it. And it does bring us all the way, almost all the way back to the beginning. We will revisit this again in another form, and there will be more arbitration coming up this fall at the U.S. Supreme Court. Gentlemen, once again, Richard Faulkner in Dallas, Phil Loria in New York, thanks for joining. The Heather Cameron's article on this morning's Monster Energy case is posted below in link, so you can read up on it there. Thank you, gentlemen.
Thank you.
Thank you, Russ, and thank you, Rick.
See
Take
y'all
care.
all in the fall. Bye.
Okay, talk to you soon.